Mr. Orme is asking this court to consider the Lackey claim that being under sentence of death for nearly 3 decades is itself cruel and unusual punishment, rising to a level that violates the United States Constitution and therefore, by virtue of the conformity clause, this state's constitution.
Florida Supreme Court is hearing a question that courts across the country have struggled with for decades. What happens when someone sits on death row for 30 years? At what point does the delay itself become part of the punishment? In this case, the defense argues that after 3 decades under a death sentence, carrying out an execution would violate constitutional ban and cruel and unusual punishment. But the justice quickly pushes back on that key problem. If the line is 30 years, why not 29? Let's take a look at the argument.
We are aware that this court has rejected similar claims in the past, but believe that there are reasons to reconsider that in light of the circumstances presented by this particular case. Mr. Orme has twice been sentenced in a manner later found to be erroneous or unconstitutional. He has never received a unanimous jury verdict. In fact, his first death sentence was handed down after a jury recommendation by a vote of 7-5, which under no stretch of the imagination would satisfy the standards that we have in place today. Moreover...
Well, Mr. Orme decided he didn't want a jury in this resentencing. Isn't that correct? I mean, he was very explicit about that.
Yes.
And there was... I mean, you're not raising an issue about his waiver of the competency.
No, Your Honor, we're not.
Or anything about the waiver. So he waived the jury, and it seems like he, at least at that point, he was willing to accept the responsibility for the crime and accept a death sentence if the judge thought that was appropriate. That's what he said, right?
I believe that is exactly what he said.
So he's changed has he changed his mind now?
Mr. Orme has not waived his appeal. There's a difference between being willing to accept the sentence of death and acquiescing in giving up the appeal to which he's entitled. He is not waiving the right to have his sentence reviewed by this court. And given his waivers of mitigation, of his presence of a jury at his third and most recent sentencing, the ground of a Lackey claim, which was argued in the trial court, is the ground that is present for this court to review today.
I could just follow up on the distinction you drew in your answer to Justice Kennedy about there being a difference between his acceptance of responsibility and waiver, which you don't contest, and his not giving up his right to appeal his sentence to this court, a distinction that I see, but now I want to press on a little bit. What remedy do you see?
The remedy in this case, based on the Lackey claim, would be to find that his sentence is unconstitutional and to sentence him to life in prison, which would still be a severe punishment fitting the crime that
doesn't that dissolve the distinction you just made? I mean, if in fact the remedy that you are seeking on his behalf is contrary to the remedy that he waived below, aren't we left exactly where you were before Justice Kennedy asked his question, which is sort of us not being able to make sense of what he really wants here?
Respectfully, no, Your Honor, because he didn't waive the right not to be killed. He waived a jury. He waived mitigation. He put his fate in the hands of a trial judge. But it was certainly possible at that point, although highly unlikely, that that particular trial judge could have sentenced him to life based on the combination of aggravating and mitigating circumstances. So no, I would say that he did not waive the right for a life sentence to be considered. And that's what's really in front of the court now. He didn't do that. I'm sorry.
The Lackey claim that you're raising here today, the whole premise of it derives from a dissent written by Justice Breyer back, 1998?
I believe that it was first Justice Stevens in 95 and then Justice Breyer in 1998.
So other than those dissents, has there ever been a majority opinion from the United States Supreme Court adopting this Lackey claim that if someone sits on death row too long, that it becomes cruel and unusual to execute them?
No, Your Honor. There's been no majority opinion either adopting or rejecting that. The court has simply refused to hear a number of cases, has allowed the decisions of lower courts to stand, but the court hasn't addressed the issue.
In this particular case, how long has Mr. Orme been on death row?
He was first sentenced to death in 1993 after his first trial. So
Listen closely to the justice's question here. This is the exact point where the argument starts to unravel.
that was
Has any other, and kind of in line with this question, has any other state Supreme Court adopted the Lackey theory to give relief?
Not yet, Your Honor. It has not
So
happened.
if we adopted this theory, we would not go against the precedent we have set,
Correct.
and we would be a singular outlier if in that respect.
We would be, yes. Although Florida has been an outlier in other respects too, and that doesn't determine whether the claim is valid or should be considered by this court.
So your position on the conformity clause is that it doesn't preclude us from being innovators on an issue as long as there's not a Supreme Court, U.S. Supreme Court decision that has directly addressed the same issue that's being raised.
That's correct, Your Honor, that there is nothing to conform to at this point in Supreme Court jurisprudence. We have,
other than on this precise issue, but the analytical framework we would need to conform to. But if it hasn't been considered in the context of this specific issue, then you think that we have free reign to do our best to apply the framework, and reach whatever conclusions.
And reach a conclusion, yes. And at that point, if the United States Supreme Court disagrees and wants to take it a step further, that court would be able to do so on review. But the court has not precluded a Lackey claim. The court has simply not recognized it to date. And one of the things that has happened and continues to happen, as documented by the Death Penalty Information Center, is that the length of time that people are being kept under sentence of death has slowly and steadily continued to rise in recent years. The age of prisoners on death row has slowly and steadily continued to rise. And at the same time, exonerations have continued to happen. According to the Death Penalty Information Center, exonerations often take anywhere from 20 to 25 years before they work their way through the justice system, and somebody who is deserving of that can get the remedy that he or she needs. Now, of course, that exoneration is not at issue here, but that is the backdrop against which I think it's appropriate and important for the courts to begin looking at the length of time we're keeping people subjected to these the conditions and the procedures.
What's the limiting principle you have to offer this court in the rule you're asking us to adopt? How long is too long for Lackey purposes?
I think, Your Honor, that it would have to be based on the circumstances of the case, the age of the defendant at the time when they were sentenced, the reasons for the delay, I think would be a part of it. The court has always considered that when rejecting those claims. I think it would still be part of the analysis. Anytime you try to draw a bright line in these cases, you're going to get a case that
you're asking us to innovate. Mm-hmm. You're asking us to outline. You're asking us to proclaim a rule. Mm-hmm. So proclaim it for me. What is the rule that you're asking us to adopt exactly?
Well, in this case, although the court has rejected similar time periods in the past, we would be asking you to hold that being under sentence of death for 30 years is itself cruel and unusual punishment.
But not 29.
Again, that's the line drawing, Your Honor.
I guess what I'm getting at is obviously you're not asking us to draw a very satisfying rule, are you?
It's not a very satisfying rule to keep people on death row for decades either, without any finality to their cases for them or for the victims, for society in general.
But, I'm just struggling a little bit here because to the extent that it is cruel and unusual punishment, it's done. That has happened.
Mm-hmm.
And so I don't even know how your remedy actually corrects what you say is wrong.
Because, Your Honor, at the point in time that the defendant or the inmate is no longer on death row, then the cruel and unusual punishment has ceased.
Well, it would cease when the execution is carried out.
Mm-hmm. That's true, but we don't know when that will happen. There are these time periods, as I said, are creeping up and getting longer and longer.
Well, but again, it just seems curious to me that in a case where the defendant basically said he wanted the death sentence, that we're here arguing about this, and arguing that this is all taking too long. When this has come here in this particular manner based on these particular circumstances.
I do have to respectfully disagree that Mr. Orme ever said he wanted the death sentence. I think what he said, and again, this you can watch this on the internet, he said he doesn't want to die, but he's willing to accept the sentence that the court hands down. So he is not seeking to die. You have seen defendants in this court before who actually have requested execution. This is not one of those.
Well,
cases.
he did say, and I actually have the transcript here, and what is reproduced from the transcript and the court's order. After he says that he doesn't want to die, he's not suicidal. He does go on to say, I'm asking basically to have my death sentence reinstated.
Mm-hmm.
He did say that.
He did say that because it had been handed down previously, and that was what it issued.
And Your Honor, I'm hoping that Your Honor, will go ahead and agree with my claim, my motion. Go ahead and just reinstate my death sentence. That's my goal.
Mm-hmm. Okay. Yeah. Again, along with the fact that he clearly said he's not suicidal and doesn't want to die. His asking for the reinstatement of his sentence has more to do with his acceptance of responsibility and the fact that he, as he said, sees that as a way to bring justice and bring this case to a close. But as was argued in the trial court, a definitive life sentence would also bring the case to the close. A definitive life sentence is subject to less review, less scrutiny, less collateral attack than a death sentence.
This case is one of the most difficult tensions in the justice system. The longer someone remains on death row, the more times the court has to review cases and catch potential errors. But at that same time, the longer the delay takes, the more complicated the punishment itself becomes. Doesn't carrying out a sentence after decades still serve as justice? Or does the delay change the nature of the punishment entirely? It's a question courts across the country have wrestled with for years. And so far, there is no clear answer. Thanks for watching Bench Breakdown. And if you want more real courtroom arguments explained and broken down, be sure to subscribe.